mid-20th century, during a time of challenges and hopeful rebuilding, from an alliance of shared passion, Rex was born, persevering through decades, sustained by faith, emboldened by vision. Rex has become a tradition of service to the nation. With its first publications, Rex pledged itself to a more proactive role in education. As evolving education required new tools and services, so did Rex expand. In the dawn of the 21st century, when education is demanded to foster learning in all forms, learning within and beyond the walls of institutions, for sustaining today for the future. We are championing education. We are now Rex Education.
Let us all welcome the best-selling Rex author, Judge Marlo Campanilla. Good evening, Judge.
Uy, good evening. Totoo yan, ha? Best-selling. Makabilong bola mo lang ako.
That's it. You may start na po.
Mag-start na ako? Please naman. Sige. So, para dun sa... Pero hindi, mag-preliminary muna ako. Yung ang book natin, yung Criminal Law Reviewer, Volume 1 at Volume 2. So, yung lahat ng principles to answer 1945 to 2019 bar examination andon, makikita nyo. No? Nilaro ko yan eh. Tapos updated Supreme Court decision. Actually, kulang sa updates yan, pero yung updated materials, binibigay ko naman yan, libre po yan. So, on top of the book, kung bibili kayo, magpapakawala naman tayo ng updated materials. I-ano na lang ako eh. Basta i-email nyo ko marlo_campanilla@yahoo.com. Mag-request kayo ng materials. Pero pag nag-request kayo, hindi siyempre immediately dadating sa inyo. Pag natapos na yung materials, bibigyan ko kayo. At saka meron akong Facebook account. Ita-type nyo lang Marlo Campanilla. No? I-like nyo o i-follow nyo para dumami yung followers ko kasi 32,000 lang yung followers ko. Yung mga estudyante ko, magpo-post lang yun. 100,000 ng followers. Hindi ko maintindihan kung... Tapos, di ba may mga bagong special laws covered by the bar examination? Mga 10 yun eh. Sinama ko na, nakasama na yun doon. Na? So, yan pa susunod na lecture to, ha? Actually, nirequest ko to sa Rex. Itong lecture na to, kasi may nag-request din sa akin na magkaroon ng special lecture, mga grupo, free online lecture. So sabi ko, Rex, pagbigyan natin. Pero siyempre, hindi exclusive sa kanila yung lecture. Para na rin dun sa mga iba, para magkaroon, kumbaga, yung entitlement mapunta sa lahat. Although yung grupo ang nag-request nito. No? Pero meron pa susunod na lecture na free lecture na naman. So, isang advertisement na lang kung okay lang ha. Meron akong sa March meron akong online lecture pero may bayad po 'yon. No, may bayad po 'yon. 7 days. selective po siya, mga Supreme Court decision, tapos mag-a-update ako, no? At ano po, maganda po yung kung kukumpletuhin niyo yung 7 days. Magbabayad kayo ng 6 days, meron ng libreng 1 day, no? Parang 400 per day yun eh. Sa March, after ng March, magkakaroon pa ulit. Free, yan, yung online lecture sa Zoom. Puntahan nyo yung page account ko, yung para makita nyo yung mga advertisement ko doon, ha? So, mag-start na tayo. So, ang lecture natin, updates on criminal prescription. This is under Article 1991 of the Revised Penal Code. No? Merong isang latest Supreme Court decision. This is the case of Lim versus People. Year number 226590, April 23, 2018. No? So preliminary lang. So according to the Supreme Court, you can object, no? You can ask for the dismiss. Kasi ordinarily, you have to file a motion to quash. Ang grounds mo is prescribed na yung crime. But according to the Supreme Court, even if you raise this issue, and that is the prescription of a crime, anytime, even during appeal, kahit na hindi ka nag-file ng motion to quash, hindi mo ni-raise nung issue, no? Yung prescription during the trial. Anytime, even during appeal, pwede mo sa erase. Hindi siya waivable. Hindi siya na-waive. So halimbawa, natalo ka sa RTC, natalo ka sa Court of Appeals, inakyat mo sa Supreme Court, biglang napansin mo, prescribed na to pwede ka bang, kasi ordinarily, pag yung mga bagay-bagay na hindi mo ni-raise, no? Ni-raise mo lang siya, first time sa appeal, wala na yan eh. Pero this is may mga exception yan, di ba? One exception is jurisdiction, di ba? So anytime pwede mong erase yan. So this is another exception, yung prescription, na? Okay tayo dyan. Now, ano ba tong article? Ano ba yung prescription? Kasi minsan binabasa natin sa libro, parang nararamdaman natin napaka-technical naman ito, no? Napaka-technical. Ganito lang po yung prescription. Kasi okay lang naman na mag-file ka ng kaso na hindi immediate, wala namang problema doon. Pero ang ayaw lang kasi ng state, yung magpa-file ka ng case beyond a reasonable period of time. Pwede ka naman mag-file kahit na late yung pagpa-file mo. Huwag lang masyadong napakatagal na, kung halimbawa after 50 years saka ipinal yung murder case, 50 years. Yung mga witnesses uugod-ugod na. Yung akusado uugod-ugod na. Pero kasi pinal mo after 50 years eh. Kaya yung nag-usap-usap sila, sabi nila, nako, parang alanganin naman na hindi natin bibigyan ng kumbaga i-allow lang natin na mag-file sila anytime. So dapat ipa-file yung kaso within a reasonable period. Now, yung nag-usap-usap sila, ano ba tong reasonable period? I-fix na lang natin para sigurado. No? Alam mo, murder, 20 years. Slight physical injury, 2 months. Pinix na ng batas. Ang tawag dun sa period na yon, yung reasonable period within which one should institute criminal action. Yung tawag din sa reasonable period, ang tawag doon, prescriptive period. Na? Kaya nga kita mo, mapapansin mo. So in other words, yung law on prescription, this is actually a pressure, no? Kumbaga the state is actually pressuring, no? The law is actually pressuring the state through the person in authority or agent or the offended party to immediately file a case. Pinipressure, yun ang essence ng prescription, pinipressure yung state, no? Through the person in authority or agent, such as police, o yung offended party. Normally, yung offended party, yung biktima eh. Pero kung ang patay na siya, ang offended party, yung heirs, no? You apply the law on succession. O na asawa, anak. O kung walang asawa, walang anak, yung parents. Pero dapat you have to apply the kung sino entitled sa diyan sa civil liability, yung award involving civil liability arising from crime, ayun ang offended party. So kung may asawa, may anak, hindi offended party ang magulang. Kung walang asawa, walang anak, ang offended party yung magulang. No? So, pine-pressure siya, i-file mo na agad 'yan. No? Kaya mapapansin nyo, no, at preliminary lang tayo Once na discovered yung krimen, dapat mag-file na ng kaso. Tumatakbo na yung period of prescription. Now, pag nag-institute naman, nag-file ng complaint or information na i-interrupt. Kasi yun lang naman nung pinag-uusapan sa prescription, i-file mo na agad yung complaint o yung information. Huwag mo nang patagalin. Dapat within a reasonable period. And that reasonable period is fixed under Article 90 of the Revised Penal Code and Act 3326. Yun ang reasonable period. I-file mo agad. Ayon. Now, so dito tayo sa general rule. Pag-uusapan natin kung kailan tatakbo at kailan ma-interrupt. So, dito muna tayo kung kailan tatakbo. So, obviously, pag yung krimen, nalaman mo na ang actually ang general rule yan from the time that the crime was committed, tatakbo na yan. Pero kung hindi pa alam ng personal authority agent or offended party, hindi pa niya alam na may krimen, hindi pa siya tumatakbo. Bakit? Kasi yung law on prescription, pine-pressure yung personal authority, yung state through the personal authority agent or the offended party to immediately file a case. Pine-pressure siya. Paano mo pe-pressurein yan na mag-file ng kaso? Hindi pa nga nila alam na may krimen. Di ba? So, kumbaga parang sinasabi mo, mag-file ka agad. Dapat within a reasonable period, i-file mo agad yan. Saglit lang. Paano ko magpa-file? Hindi ko pa nga alam. So, pag nalaman ko na may krimen, saka lang sa tatakbo. No? Kami, may mga tanong sa bar na a witness discovered a crime. Tapos, later on, after 20 years, pumunta lang po ako ng Amerika na-witness ko po yung pagpatay. Saan nilibing? Ito po, tinuro, dyan po nilibing. Meron pa ako video. Kompleto sa ebidensya. Tinago ko pa nga yung baril So, ang tanong, prescribed na ba? Kasi penal after 20 years. The witness is not a personal authority. The witness is not an agent of a personal authority. The witness is not an offended party. And therefore, hindi tumakbo yung period of prescription. Tatakbo lang siya upon discovery of yung nireport sa police. Police kasi agent of a personal authority, doon lang tatakbo yung period of prescription. So okay tayo dyan. Now, may mga time, if you will consider the letter of Article 91 of the Revised Penal Code, tatakbo yan, yung krimen, tatakbo yung period of prescription upon commission or discovery of the commission of the crime. Ayun yung letter. Pero may mga time kasi that the Supreme Court is taking into consideration the spirit that giveth life rather than the letters that kill it. Ang tinitingnan yung spirito, hindi yung letter. Kasi pag kinonsider mo minsan yung letter, it goes against the spirit of the law on prescription, magkakaroon ng absurdity. So, isa-isahin natin. So, for example, kung if the crime is a continuing crime, this is actually the case of Arquez versus Bellasilia. No, this is GR number L1779, June 29, 1948. No? Halimbawa, yung crime is a continuing crime. Ano kasi sa river, nag-install siya ng may mga dike, no? Bawal 'yon under the law. Kasi dapat kumbaga, dapat yung mga tao magamit yung river para mag-navigate sila. Nilagyan mo ng mga dike hindi nila magamit. Kaso pinail nung kaso after 4 years. Sabi niya prescribed na to. Ang prescriptive period 4 na taon lang Pinail mo after 4 years kaso sabi ng Supreme Court kasi pag tinignan mo yung Act 3326, ganun din yan, discovery yan commission or discovery. Alam nyo na, nagsayo ka ng dike dyan, dapat pinail mo na. Pero ano sinabi ng Supreme Court? Considering that the crime is continuing, no? The period of prescription will commence to run upon the ending of the continuing character of the crime. So in other words, hanggang you are committing the crime, hindi tumatakbo yung period of prescription. Kasi pag tinektekal mo yan, i-consider mo yung letters. Tingnan mo yung letters. Alam mo na, di ba? Nagtayo ako ng dike nagtayo ka ng dike Pero Supreme Court, hanggang hindi natatapos yan. Kasi although pinail yan after 4 years, andun pa rin yung dike which is a continuing violation of the law. Halimbawa ganito, no? Hino-stage mo yung tao. Pare, January 1 ngayon, 2020. No? Hino-stage kita ngayon. Yun. Now, after 20 years, nakawala yung biktima. Nag-file ng kidnapping case. Sabi nung akusado, di ba yung kinidnap kita, binanggit ko yung date? Oo. At sinabi ko, hostage kita, kinidnap kita, di ba? Kinalaro ko sa iyo yun. Oo. Di. So alam mo na kidnap victim ka. Sir, alam ko. Prescribe na. Kasi dapat pinail mo yung kaso within 20 years. Napamura yung nagalit yung biktima. Napamura, putang ina. Paano ako makakapag-file ng kaso sa'yo? Nakakulong ako. Di ba? Kasi pag tiniktikal mo yung, sige, tektikalin natin. Consider natin yung letter ng Article 91 of the Revised Penal Code. Tatakbo na. Kasi alam mo na. Di ba? Kinidnap kita. Sinabi ko pa sa iyo yung date mo. Kailan kita kinidnap Alam mo na. Pag kinonsider mo yung Article 91, tatakbo na yun. So in other words, the Supreme Court considered the lack of capacity, no? So you have to consider the capacity to institute. Kasi nga, pinipressure mo mag-institute, hindi naman pwede mag-institute kasi nakadetain nga siya No? That is the spirit of the law on prescription. And the spirit is that this is a rule that which pressure the offended party to immediately file the case within a reasonable period. That is 20 years, considering that the crime committed is kidnapping. Napaka-absurd na pressure mo na siya mag-file ng kaso. Wala naman siyang kapasidad mag-file. Kasi nga, kidnap victim siya. Ayun. Now, another case where the Supreme Court considered the spirit and not the letters. This is the case of People versus Naneha. GI number 47684, June 10, 1941. Ang pinag-uusapan rito, false testimony under Article 80 of the Revised Penal Code. False testimony against the accused. Na? Kaso, pag tinignan mo yung penalty sa Article 180, no? Yung false testimony, ang penalty niyan will be based kung convicted or acquitted. So, prior to the finality of the judgment of acquittal or conviction, the crime of false testimony is not yet actionable. In other words, hindi ka makapag-file ng kaso. Pag nag-file ka ng kaso, di-dismiss yan, prematurity. Why? Kasi kung mag-file ka ng kaso, anong penalty? No? So, hindi siya actionable. No? And that is the reason why, according to the Supreme Court, the period of prescription will commence to run not from the time the crime was committed, not from the time that the commission of the crime was discovered. Actually, pag tinan mo, basahin mo yung Article 91 of the Revised Penal Code. Pag kinonsider natin yung letters niyan, discovered na ba? Oo. Kasi, di ba pag nag-testify ka, dyan yung judge, andyan yung abogado, di ba, stenographer. Oh. Di ba? Na-discovered siya at the time that the testimony concerning untruthful matters was made. And yet, the Supreme Court did not consider the letter of Article 91. What was considered is the spirit. Paano mo pe-pressurein? Kasi ang spirito niyan, no? Pine-pressure yung offended party na mag-file ng kaso. Paano mo mape-pressure yan? Hindi pa pwede mag-file ng kaso. Now, binanggit ko yung limb, no? Limb versus people kanina, di ba? At meron kasing old case yung Reyes case, no? Itong Reyes case, this is an old case at fortunately, nire-affirm ng case of limb. Sadali lang. Bago tayo pumunta rito sa limb, balik muna tayo dun sa false testimony. Maiksi lang to, Alam mo yung pinag-uusapan yung dun sa Maneha case, false testimony against the accused under Article 80. No? Halimbawa, ganito sitwasyon, false testimony under Article 81. That is, false testimony in favor of the accused. O tsaka yung false testimony in a civil case under Article 82. O false testimony in other proceedings such as administrative case. Article 183 of the Revised Penal Code. Ito mapapansin mo, yung false testimony in favor of the accused, false testimony in a civil case, false testimony in an administrative case, the penalty will not depend on the result of the proceedings. So at the time that you made a false testimony, the crime is already actionable. So ang tanong, will you apply the Maneha principle if what is involved is prescription of a crime of false testimony in favor of the defendant in a civil case, in favor of the accused in a civil case or administrative case? You will not. Kasi actionable na siya at that time that the false testimony was made. That is also the opinion of Justice Florence Regalado. That up to now, yung grade sa bar examination yan is unbeatable. Napakagaling na justice. Now, so balik tayo sa lim. Nung rim kasi, di ba binagit ka ng GR number niya, nire-affirm niya yung Reyes principle. May mga time kasi, na ang pinalsify mo is yung deed of sale. No? Pinalsify mo yung deed of sale. Usually kasi, pag nagpalsify ka ng deed of sale, alang naman habang pinapalsify mo, nakaharap yung may-ari. Yung signature ng complainant. Ito, pinapalsify ko yung signature mo, di ba? So usually, Pag nag-falsify yan, hindi alam na complainant ng biktima. Ngayon, deed of sale. Binenta yung property. Ni-registered sa di ba hawak niya yung title eh. Tapos deed of sale pineki. Halimbawa, yung kapatid mo, tol, nasa Amerika ako, hawakan mo tong deed of sale. No? Hawakan mo yan. O yan. Ginawa ng kapatid, pinalsified, hawakan mo tong title pala, I'm sorry. Nasa Amerika ako, hawakan mo tong title. No? Dito meron akong lupa eh. Bahay at lupa. Ginawa ng kapatid, pinalsify yung deed of sale. No? Pinalabas na binenta. So, at the time that he falsified the deed of sale, for obvious reason, hindi alam ng kapatid niya. Alam na, alam na sinabi niya. No? Tol, kung halimbawa, immediately when the deed of sale was falsified, no? Nalaman ng kapatid, may nagsumbong, pamangkin, pinalsify yung deed of sale, tatakbo na yon. No? Tatakbo na yon. Pero halimbawa, ganito yung sitwasyon. So, pinalsify yung deed of sale, hindi alam ng kapatid. Kasi pag pinalsify, sa CR lang yan eh. Di alam. Tapos, pumunta sa Registry of Deeds. Ito yung title, ito yung deed of sale, tax payment. So, pinakancel yung title, nag-issue ng bagong title. Tapos, after, ang period of prescription sa falsification, 10 years. After, palagay na natin, 11 years, nalaman ng kapatid na pinalsify yung deed of sale niya. Pagdating niya, hindi na sa kanya, yung title niya, canceled na. So, nag-file siya ng kaso. Prescribed na ba? Alam mo, the Supreme Court at apply the constructive notice rule. So, what is the constructive notice rule? So, at the time that the deed of sale was registered in the Registry of Deeds, that is a constructive notice to the whole world, including the offended party. No? So at the time na na-register niyan, meron ng tinatawag na constructive notice, so meron ng constructive discovery. So walang actual discovery kasi the actual discovery happens after 10 years. Pero nagkaroon ng constructive discovery. And therefore prescribed na, sabi ng Supreme Court. Ako lang ha. I will not agree with this Supreme Court decision. Kasi, ang law of prescription, pinipressure mo yung offended party na mag-file agad ng kaso. Paano magpa-file agad ng kaso yan kung ang notice is constructive? Dapat actual notice. No? Kasi alam mo yung constructive notice rule, ano yan eh. Sa torrents title yan eh. Para ma-settle na yung kung sino ang owner ng property. Sa akin, dapat hindi ina-apply yan sa criminal case. Pero at the end of the day, I'm not a justice. Hindi naman ako Supreme Court. So we have to follow the Supreme Court decision. Sinasabi ko lang yung opinion ko, pero we have to follow the Supreme Court decision for purposes of the bar examination, practicing law. That is a Supreme Court decision. So you apply the constructive notice rule, dapat mag-file ka na. Sir, hindi ako makapag-file, hindi ko alam eh. Notified ka na constructively. No, yun ang sinabi ng Supreme Court, no? Old case yan eh, yung Reyes, pero nire-affirm ng Lim. Doon sa libro ko pa, meron ako doon sa year 2000 na book ko, paki-check na lang kasi yung mali yung citation ko doon eh, kasi parehas na date. Pero ang tamang citation niya, Lim eh. Lim versus People. No? Now, merong isang kaso, sermonya, which was affirmed, this sermonya was affirmed in the case of Charillo. Charillo, oponente nito si Justice Peralta. September, ano to? 9. September 16. 2009. No, September 9, 2009 pala. Parang po. GR number nito. Babay mo na, GR number. So, kung halimbawa ganito, nagpakasal ka, tapos, nagpakasal ka ulit for the second time. So, ang bigamy kasi, ang period of prescription niyan, bigamy, ang GR number niyan, 1644 35. September 9, 2009. Now, so, nagpakasal ka. Siyempre, nakatira ka sa Manila. Ang ginawa mo, nagpakasal ka ng pangalawang beses sa Cebu. Siyempre, kasi pag nagpakasal ka sa Manila, malalaman ng mga kapitbahay mo nagpakasal ka, sasabihin sa asawa mo, nagpakasal na ulit yan, ho. Makakasuhan ka. Kaya ang ginawa mo, pumunta ka sa malayo lugar. Hindi, palagay na natin, sa Cebu o kaya sa Hulo. Malayo. Oh. So, walang nakakaalam na nagpakasal ka ng pangalawang beses. Di ba yung marriage certificate, nire-register niya sa civil registrar. Oh. After 15 years, nalaman ng asawa mo sa Manila na nagpakasal ka ng pangalawang beses sa Hulo, Mindanao. Nag-file ng bigamy case. Now, ang argumento ng akusado, we apply the res principle, no? Reaffirm in the case of limb, constructive notice. So at the time that the marriage certificate was registered in the civil registry, no, there is a constructive notice to the whole world, including the offended party, that yung nga nagpakasal ng pangalawang beses yung asawa. The Supreme Court rejected the argument. According to the Supreme Court, the constructive notice rule is not applicable to registration of marriage contract. Bakit hindi applicable? Kasi yung constructive notice rule nasa law on torrents title system, di ba? Torrents system. No? Nasa ano yun sa law on yung property registration law. Ngayon, pagdating kasi sa registration ng marriage contract, ang pinag-uusapan rito family code at saka yung law on civil registry. And there is no constructive notice rule under the family code at saka civil registry. So the Supreme Court rejected. So hindi pa sa prescribed. Hindi pa sa prescribed. So okay na tayo dyan. So dito muna tayo sa interruption. Now, under Article 91 of the Revised Penal Code, may interrupt yung running of the period of prescription upon filing of a complaint or information. Complaint or information. No? Now, in the case of people versus Francisco. This is GR number 45674. May 30, 1983. Dito, no? 1983. In the case of people versus Francisco, ano sinabi ng Supreme Court? Ang pinag-uusapan dyan, slight physical injury. In-interpret niya yung Article 91. Sabi ng Supreme Court, nakalagay ito complaint or information. No? So sinabi ng Supreme Court, there are two kinds of a complaint. No? Number one, complaint affidavit to be filed with the fiscal, ombudsman, for preliminary investigation. Saka complaint involving yung mga ano, 'di ba, yung mga crime na yung mga private crimes that 'di ba? Complaint to be filed in court for trial on the merits. No? So dalawang klase ang complaint eh. Kasi nakalagay sa 91, filing of complaint or information. Hindi naman sinabi filing of complaint or information in court. So kailangan magkaroon ng interpretation. Sinabi ng Supreme Court, dalawang complaint eh. No? Yung pinapile sa fiscal for preliminary investigation tsaka yung pinapile sa korte. No? Di ba, pag acts of the sea business, dapat complaint yan, hindi dapat information yan. So, the law did not make a distinction between a complaint to be filed with the fiscal for preliminary investigation and a complaint filed in court for trial on the merits. So, if the law does not distinguish, the court must not distinguish. And therefore, the filing of a complaint for preliminary investigation with a fiscal or ombudsman, or the filing of a complaint or information in court for trial on the merit will interrupt the running of the period of prescription. Di ba, in-explain ko na sa inyo na yung law on prescription, pinipressure yung offended party na mag-file agad. So pag nag-file siya na agad sa fiscal, sa korte, interrupted na. Kasi yun lang naman pinag-uusapan doon eh. No? Yun lang naman pinag-uusapan doon. Now, itong Francisco, no? Kasi yung rules on criminal procedure, ni-revise yan December 1, year 2000. No? So when they revise yung criminal procedure on December 1, year 2000, yung ni-revise nila, they adopted the Francisco Doctrine. No? Basahin mo yung libro ni Herrera na yung revision, yung rule section 1, rule 1110 of the Rules on Criminal Procedure, adopted the Francisco Principle. Kaya ang nakalagay doon, yung institution, di ba? What is a criminal institution of criminal action? Di ba pag nag-file ka ng complaint for preliminary investigation sa fiscal, that is institution of criminal action. O, di ba? Oh. So magkakaroon na yung institution of criminal action will interrupt the running of the period of prescription. No? So inadopt na yung Francisco. Now, in the latest case of De La Cruz ata ito Del Castillo, ito yung GR number kasi baka nagkamali ako sa title pero parang De La Cruz Ang GR number 199030. June 27, 2018. Parang Del Rosario ata o basta kunin niyo na lang yung GR number 199030 yon. Del Rosario ata. No? So the case of Del Rosario reaffirm the Francisco Doctrine, no? Nire-affirm niya yung Francisco Doctrine. So okay na tayo dyan. Del Castillo. Parang Del Castillo, Del Rosario, Del Castillo. I-double check nyo na lang, ha? I-double check to, i-chat nyo na sa akin. Paki-chat nyo nga. Please. 199030, ha? Paki-chat nyo, ha? Del Rosario ata. Now, I'm sorry, ang nag-reaffirm pala ng Francisco Lim. I'm sorry, no? Lim case. Iba pala itong pero yung susunod na lecture natin kasi itong Del Rosario, no? So yung Lim case ang nag-reaffirm ng Francisco. So susunod na lecture natin is Del Rosario, no? So, dito tayo sa Act 3326. Act 3326. Na? Act 3326. So, pag yung kanina, yung discussion natin sa Article 1991 of the Revised Penal Code, felonies yun. Kung ang pinag-uusapan natin, violation of a crime, punishable under special law, or violation of ordinance. So, Article 1991 of the Revised Penal Code is not controlling. The governing law is Act 3326. Act 3326. Ayun. So i-discuss natin yung commencement tsaka interruption. So dito muna tayo sa commencement. Commencement. So pag-usapan natin yung binanggit ko na no? Del Rosario, no? 199030 2018 to. June 27, 2018. Okay tayo ito. Now, itong Del Rosario, diniscuss ng Supreme Court yung blameless ignorance doctrine. What is this blameless ignorance doctrine? Under this blameless ignorance doctrine, the statute of limitation, the court shall refuse to apply the statute of limitation if the offended party or the personal authority or agent has no reasonable means to know that the crime has been committed. So in other words, the period of prescription will not commence to run if the offended party or the state has no reasonable means to know that the crime has been committed. Kasi kung bakit untitled blameless ignorance doctrine? Hindi in-explain na Supreme Court, ako na mag-explain sa inyo. Bakit untitled blameless ignorance doctrine? Kasi pag ignorante ka, ignorance, di ba? Ignorante ka that the crime has been committed. Hindi mo alam, ignorante ka that the crime has been committed. You should not be blamed for not filing immediately the case within a reasonable period of time fixed by law, which is called period of prescription. Hindi ka pwedeng sisihin. Hindi mo alam na may krimen So, bakit ka magpapile, paano ka magpapile agad ng kaso kung hindi mo nga alam? Bakit ka i-blame? Prescribed na yan Sandali lang, wag mo kong sisihin dyan. Wag mo ko i-blame dyan. Ignorante ako na you committed a crime Hindi ko naman alam yan ayun yung blameless ignorance doctrine. Ang isang in this case of Del Rosario, the Supreme Court discuss yung Desierto case, yung Dicini case, yung Gutierrez case, itong discuss, itong mga kaso na to na nasa discussion ng Del Rosario, ang pinag-uusapan rito yung behes loan. Ano ba yung behes loan? Yung word na behes, ano yan? Order ng hari. Ayun yung behes So pag sinabi mong behes loan, in-order lang ng higher authorities, for example, the president, land bank, ito. Kasi during the Marcos time, although I'm not saying that talagang si Marcos may mga behes loan pero ano lang para maintindihan nyo lang yung ng todo-todo. may mga writers, no, I'm not saying na may evidence na totoo yung sinasabi ng mga writer. May mga writer na sinasabi na Marcos adopted the crony capitalism. So under the crony capitalism, no, yung mga crony niya, yun ang magpapasok sa mga negosyo, mga telepono, eroplano, gano'n, no? Sabi ng crony, bossing, medyo kulang ang pera natin. No problem, land bank. Ibigay mo yung pautangin mo to. Sir, wala namang pang collateral. At saka kulang sa mga requirements. Pautangin mo. Ayun. Sige, pinautang. Ang tawag doon, behes loan. Pinautang dahil inutos na ipautang. Hindi dahil nasumunod sa normal na proseso na dapat may collateral ka, magpipresenta mo, ano ba yung project mo, sa mo dadalhin to, may mga yan eh. May proseso. So, hindi dumaan sa proseso. Pautangan mo yan. Ang tawag doon, behes loan. Now, so for obvious reason, may kaso yung, kasi, halimbawa, yung section 3G of RA 3019, di ba? At, kasi yung contract, yung behes loan, that is a contract which is disadvantageous yan sa government. Di ba? Sa section 3G of of RA 3019, the Anti-Graft and Corrupt Practices Law, di ba? Entering into a contract which is on behalf of the government, which is manifestly disadvantageous on the part of the government. That is a violation of RA 3019. For obvious reason, yung mga behes loan, that is a violation of section 3G. At saka pwede din yan sa section 3E eh. Di ba? At giving unwarranted preference, advantage, causing undue injury to the government through manifest partiality, evident bad faith. Now, dito sa mga behes loan, yung pinail nila, kasi dati ang period of prescription sa RA 3019, 10 years, tapos ginawang 15. Pero ngayon yung latest inamendahan kasi yan yung section 19 ng RA 3019 ng RA 10910 at amended ang period of prescription 20 years. Ngayon, pero pag mapapansin niyo yung mga kaso na dinidiscuss ng Del Rosario, such as Desierto at Disney, no? Medyo mababa yung period of prescription, may-exit 10 years. So, ang tanong, prescribed na ba? No? Kailan tatakbo? Sabi ng Supreme Court, prior to the EDSA Revolution number 1, prior to the ousting of the President Marcos because of the EDSA Revolution, the period of prescription will not commence to run. Why? Kasi, during that time, nobody dares to question a transaction involving behes loan. Kasi may blessing allegedly may blessing ni Marcos yun. At saka there is no way to know that is a behes loan because the information are not available. Pupunta ka ng land bank, umutang daw to alam ko, crew rin yan umutang daw. Pwede yung makita yung mga dokumento. Hindi mo makikita yung mga dokumento. So, paano mo malalaman na behes loan yun? Paano mo malalaman na hindi dumaan sa normal na proseso yun? Paano mo malalaman na may violation ng RA 3019? Walang ebidensya. Kasi according to the Supreme Court, no, the public officer, such as yung officer ng land bank, and offended pa yung offender, no? Yung na-benefician, such as yung mga cronies, are conspiring, no? They are conspiring and they are suppressing information or evidence that they violated RA 3019. So in other words, ang kinonsider ng Supreme Court rito is that, kasi di ba sa law on prescription, mag-file ka na within a reasonable period. Paano nga kami makakapag-file? Hindi nga namin alam na may violation ng RA 3019 kasi walang ebidensya. Hindi kami makakuha ng dokumento. And kaya sabi ng Supreme Court na tatakbo lang yung period of prescription involving violation of RA 3019, no? In connection with behest loan after EDSA Revolution number 1. Ngayon, after masyadong ano no, masyadong no. Pero may isa pang Supreme Court decision na after siya, pero after the government conducted an exhaustive investigation and discovered that the loan, no, and na pinautang ng land bank sa isang alleged crony is a behest loan, which is a violation of RA 3019. Doon lang sa tatakbo. Kasi pag pinapatakbo mo na yan, kumbaga ibig sabihin, pag tumatakbo na yung period of prescription, pinipressure mo na mag-file ng kaso. Paano nga makakapag-file ng kaso? Hindi nga alam na may kaso. No? Yung isang sinay sa Supreme Court, yung DCN case no? O ano yung DCN case? Yung nuclear power plant project. Although sinabi ng Supreme Court, naka-televise yan na magkakaroon ng nuclear power plant project. Ang problema, yung mga dokumento, hindi ka makakakuha ng kopya. And that is the reason why hindi pa tatakbo ang period of prescription. Hindi sa tatakbo. No? Now, dito tayo sa, di ba ang pinag-uusapan natin is yung Del Rosario, di ba? Pinag-uusapan natin. So what is the crime involved in Del Rosario? This is yung yung sa SALN. No? Yung failure to file SALN. So sinabi ng Supreme Court dito. Para tumakbo ang period of prescription, merong dalawang rule, general rule at saka exception. General rule at saka exception. So what is the general rule? No? Tatakbo siya upon the commission of the crime. Immediately when the crime is committed, tatakbo na yan. Na? Sinuntok ka. Slight physical injury, tatakbo na yung period of prescription, 2 months. So the general rule, commission of the crime, tatakbo siya. Now, but according to the Supreme Court, merong second rule. No? Merong exception. Yung exception nito, if at the time the crime was committed, the personnel authority agent or the offended party are not aware, no? Are not aware that the crime has been committed. And therefore, the period of prescription will commence to run upon discovery. No? Upon discovery. Now, sabi ng Supreme Court, ang rule, you apply the general rule. No? Yun. Ngayon, pero ano yung instance where you can apply yung exception? Ayun nga, yung upon discovery. Now, to apply the exception, and that is discovery of the crime, you will consider, according to the Supreme Court, availability or suppression of information regarding the commission of the crime. No? Kasi yung during the time ng Marcos, hindi available yung mga information regarding behest loan. Sinusuppress yung information regarding behest loan. No? So, to consider the exception, to apply the exception to the general rule, and that is the period of prescription will commence to run upon the discovery of the crime, you will consider, number 1, availability of information. regarding the commission of the crime. Or, number 2, suppression of information. No? So, availability tsaka suppression. No? Eh, sabi ng Supreme Court, under the law, ang SALN is accessible to the public, available to the public, at walang suppression. Available at hindi siya nakasuppress. And therefore, the period of prescription will commence to run from the date of the commission of the crime. And that is the expiration of the period within which one should file SALN. Na? Ayun yung Del Rosario. Now, tubig. Now, sa violation of ano tayo? Sa violation of BP22. No? Violation of BP22. Kailan ba tumatakbo yan? Alam mo yung period of prescription. Alam mo yung nasa Manila ako, fiscal ako doon. Ang policy ng opisina namin, tatakbo siya upon the issuance of the check. Ako, I respect yung policy ng Office of the City Prosecutor in Manila. Subordinates lang ako eh. Wala naman tayo, hindi naman, kumbaga. Pero, I respect, but I will not agree. Bakit? Ang period of prescription, the law on prescription, this is in effect a law that pressures the offended party to immediately file a case within a reasonable period of time fixed by it. Na? Ngayon, pag issue mo ng check, may krimen na ba? Bakit mo pipressurein yung offended party na mag-file ng kaso? In-issue mo pa lang yung check. Kaka-issue pa lang yung check, magpa-file na ako na agad ng kaso. At saka, di ba, prescription of crime? How can you describe that as prescription of crime if there is no crime at that time that the check was issued? Kasi, the crime will be committed upon the bouncing of the check, not upon the issuance of the check. So, at the time that the check was issued, wala pang krimen. O paano nagkaroon ng prescription of crime if there is no crime to speak of? Hindi mo pa nga, kung di tumalbog yan, so nag-file ka na ng kaso. O sige, pagka-issue ng check, pagkahawa ko ng check, sabi nung law prescription, mag-file ka na ng kaso. O sige sir, magpa-file na agad ako. Nag-file ka ng kaso. Hindi naman tumalbog. Di ba katawa-tawa yon? Now, so, for obvious reason, yung date of the issuance of the check should not be considered as a factor that will trigger the running of the period of prescription for violation of PP22. Malabo po yun. Wala pang krimen Ba't na prescription of crime? Wala pang ang krimen. No? Now, kailan ba nakukumit yung krimen? Kailan nakukumit yung violation of PP22? In the case of Bautista, upon the dishonor of the check, the crime is already consummated. Paano yung notice of dishonor? Yung notice of dishonor is not an element of violation of PP22. But that is an indispensable requisite to file a case. Kasi prior to the receipt of the notice of dishonor and the expiration of the 5 banking days from receipt of dishonor, hindi ka pwedeng mag-file ng kaso. Madi-dismiss siya, no? Not because the elements of violation of PP22, an element of violation of PP22 is not present. But simply because magkakaroon ng violation of due process of law. Why? Kasi yung batas kasi binigyan ng opportunity yung yung drawer not to prevent criminal to prevent from being prosecuted for violation of PP22 by making good of the check, no, within 5 banking days from receipt of the notice of dishonor. So pag walang notice of dishonor, you are depriving the accused of due process of law. No? Kaya kita nyo kaya yung notice of dishonor hindi sa element yung ng violation of PP22. Kasi pag halimbawa walang notice of dishonor, pag nag-file ka ng madi-dismiss nung kaso not because the prosecution failed to prove the elements of violation of PP22, but simply because there is deprivation of due process of law. And that is nawawala yung opportunity to make good of the check for purposes of averting criminal action. No? And that is within 5 banking days. Now, so in other words, at the time na na-dishonor yan ng bangko, yung violation of PP22, committed na siya. Pero hindi pa siya actionable. Bakit? Magiging actionable siya upon the expiration of the 5 banking days from receipt of the notice of dishonor. Doon siya magiging actionable. Why? Kasi although na-commit na yung krimen, mag-file ka ng kaso, wala pang notice of dishonor, ma-dismiss yan. Not because of failure to establish the elements of violation of PP22, but because of deprivation of due process of law. No? So ang tanong, kailan tatakbo yung period of prescription? From the date of dishonor or from the expiration of the 5 banking days? 5 banking days from receipt of the notice of dishonor. Tatakbo siya not from the date of the dishonor but from the date of the expiration of the 5 banking days from the receipt of the notice of dishonor. Why? Diba sa maneha, yung false testimony committed na and yet hindi sa actionable. So, yung tatakbo yung period of prescription from the time na naging final na yung judgment of conviction or acquittal, from the time na naging actionable na siya. Kasi bakit mo siya pe-pressurein na mag-file ng kaso kung hindi pa siya pwede mag-file? Ganun din sa violation of PP22. Why would you pressure the offended party to file a case involving violation of PP22 if he cannot file a case? Because the crime is not yet actionable. It will become actionable upon the expiration of the 5 banking days from receipt of the notice of dishonor. The notice of dishonor. Doon lang sa magiging actionable. No? Kasi it will be absorbed that you will let the period of prescription running and yet there is no way for the offended party to interrupt the running of period of prescription because he cannot file a case. Tatakbo lang yan kung meron na siyang capacity to file a case. No? And that is the reason why in the case of People versus Pangilinan, this is GR number 15266-2. Parang June 13, 2012. Pangilinan. The Supreme Court said that the running of the period for prescription for violation of BP 22 will commence to run in the year where the complainant received the notice of dishonor. Ha? So, okay na tayo dyan. Now, dito tayo sa interruption. Dito tayo sa interruption ng period of prescription. Now, involving an offense punishable under special law. So, ang pinag-uusapan rito is Act 3326. This is the case of panagiton, panagiton, yung interport, pangilinan. Yung nga, panagiton, interport, pangilinan, which was reaffirmed by the latest Supreme Court decision. This is Lee versus People. People versus Lee ata. GR number 234 6/18 September 16, 2019. Na? So, latest Supreme Court decision Lee. So, itong Lee, nire-affirm niya yung panagiton, sec interport, no? At saka pangilinan principle. Ngayon, so pinag-uusapan natin rito is a crime punishable under special law. So, yung period of prescription nasa Act 3326. Now, bago tayo magpanagiton, pangilinan, sec interport, yung interport case at saka Lee. Dito muna tayo sa Saldivia. No? Yung Saldivia, ang ponente nito si Justice Isagani Cruz. Napakagaling po niyan. Parang 1992 to eh. Parang July 3, 1992. This is an old case penned by Justice Isagani Cruz. Sabi ng Supreme Court through Justice Isagani Cruz, Saldivia to ha. Eh kasi pag binasa mo kasi yung Act 3326, what will interrupt the running of the period of the prescription is the institution of judicial proceedings for punishment, for investigation or punishment. No? Institution of judicial proceedings for investigation or punishment. So, sinabi ng Supreme Court sa Saldivia, judicial proceedings eh. No? So, ang word ng judicial proceedings. So, to interrupt the running of the period of procedure, to interrupt the running of the period of prescription, no? It is important that there must be a filing of a complaint or information in court, no? Kasi judicial proceedings eh. So, the filing of a complaint for preliminary investigation with the fiscal office or ombudsman will not interrupt the running of the period of prescription. Why? Because the proceedings, the preliminary investigation is not a judicial proceedings. So that is Saldivia, 1992. No, however, it was abandoned by the Supreme Court in the case of Panikiton at Interport, Pangilinan, and the latest Supreme Court decision, Lee. Yung Lee, this is 2019. No? September 16, 2019. No? 234, 618. No? Bakit niya inabandon yung Saldivia? Bakit niya inabandon yung Saldivia? Ganito po. Kasi yung Act 3326 was approved on December 4, 1926. December 4. So, the procedural situation in 1926 is different, no? In 2000 at is different today. Iba yung procedural situation nila. What is the procedural situation? Ganito po yung procedural situation dati, no? Dati kasi, yung 1926, ang piskal hindi nagkakandak ng preliminary investigation. Ang nagkakandak ng preliminary investigation yung Justice of Peace. Considering that it was the Justice of Peace who is, which is conducting preliminary investigation. So yung pinraise nila, yung sinulat nila yung Act 3326, nilagay nila judicial proceedings, institution of judicial proceedings for investigation. Ano yung ibig sabihin yun? Ano yung ibig sabihin institution of judicial proceedings for investigation? And that is the filing of a complaint for preliminary investigation with the Justice of Peace. Na? Ano naman yung institution of judicial proceedings for punishment? That is the filing of a complaint or information in court, Justice of Peace at court of first justice, a judge of the court of first instance for trial on the merit. No? Ngayon, sabi ng Supreme Court, ngayon kasi yung present judicial setup is now different. In the court, the judges are not authorized to conduct preliminary investigation. Kahit na yung MTC, hindi na pwede. Ang nagkakandak na yung fiscal. And therefore, because of this, judicial proceeding should be interpreted as administrative proceedings and judicial proceedings. No? So the judicial proceedings mentioned in Act 3326 should be interpreted as administrative proceedings for investigation and judicial proceedings for punishment. Now, what is the meaning of institution of administrative proceedings for investigation? That is the filing of a complaint for preliminary investigation with the fiscal or ombudsman. Now, what is the institution of judicial proceedings for punishment? That is the filing of a complaint or information in court, MTC, RTC, Sandigan Bayan, for purposes of trial on the merit. So in other words, the filing of a complaint for preliminary investigation, with the fiscal or ombudsman or SEC, what is involved is violation of yung law on yung security and exchange law, that filing of complaint will interrupt the running of the period of prescription. Kaya nga according to the Supreme Court in the case of Pangilinan, Pangilinan, sinabi ng Supreme Court, whether the crime is punishable under the Revised Penal Code or whether the crime is a felony punishable under the Revised Penal Code or an offense punishable under special law, the filing of a complaint for preliminary investigation with the fiscal will interrupt the running of the period of prescription. Pero siyempre, yung Romualdez case kasi importante na dapat yung proceedings is a legal proceedings. Kasi 'di ba yung sa Romualdez case nag-file ng kaso sa sa PCGG, involving against a crony for violation of RA 3019. Sabi ng Supreme Court, yung investigative authority ng PCGG is only applicable if what is involved is a crime in connection with ill-gotten wealth, alleged ill-gotten wealth during the Marcos time. So halimbawa, charge mo yung crony, alleged crony, violation of RA 3019 involving the ill-gotten wealth of the allegedly of the Marcoses, may authority ang PCGG. Kasi ang function talaga ng PCGG, i-recover yung ill-gotten wealth. Pero kasuhan niya yung alleged crony ng violation of RA 3019, hindi naman in connection to the recovery of ill-gotten wealth, wala siyang authority. And that is the reason why, according to the Supreme Court, the proceedings before the PCGG did not interrupt the running of the period of prescription because that proceeding is unconstitutional. Void. A void preliminary investigation will not interrupt the running of the period of prescription. Now, so okay na tayo dyan, no? 5 minutes, si-share lang ako ha. Share. 5 minutes. Eto ha. Dito tayo sa Jadewell. Kasi yung, di ba, binabangkit ko yung latest Supreme Court decision, yung Lee. Yung Lee, di ba? 2019, di ba? Yung Lee case. September 16, 2019. Binanggit niya yung diniscuss niya yung Jadewell. Naging issue din yung Jadewell. Pero dito muna tayo sa Jadewell Parking System Corporation versus Lidua. Ang ponente nito si Justice Leonem, GR number 169588, October 7, 2013. Ang pinag-usapan natin dito, violation ng ordinance. So yung violation ng ordinance, ang period of prescription niyan, two months. I'm sorry ha. Bago tayo mag-Jadewell, meron pa ako isa palang ile-lecture, no? Di ba yung RA 3019, ang period of prescription niyan is 20 years. Nasa section 19 ng RA 3019. No? Now, di ba yung Act 3326, ang pinag-uusapan doon, period of prescription, commencement, saka interruption. No? Ulitin ko, yung Act 3326, Special Law Ordinance, no? Period of prescription, interruption, no? Commencement saka interruption. Ngayon, Dito sa RA 3019, yung period of prescription, nasa Section 19. Now, pagdating sa period of prescription involving a crime, no, punishable under RA 3019, you consider, what is controlling is not Act 3326. No? Ang controlling diyan yung Section 19 ng RA 3019. No? Ayun. No? Pero pagdating dun sa commencement saka running, wala sa Section 19. Yung commencement saka running. So pagdating sa commencement saka running, you still apply Act 3326 as interpreted in the case of panigiton, pangilinan, etc. Na? Ulitin ko So even if the special law provides a provision on period of prescription, and therefore Act 3326 is not anymore applicable. But if the special law, usually hindi nagbibigay ng rule yan sa commencement saka sarani, commencement saka interruption So walang provision on commencement saka running. So pupunta ka pa rin sa Act 3326. No? As interpreted by paniguton, pangalinan, and therefore the filing of a complaint, no, for preliminary investigation with the ombudsman, tatakbo siya. In fact, in the case of Lee, no, yung 2019 case, ang pinag-uusapan diyan sexual harassment Sa yung RA 7877 7977 o 7877, paka-check na lang. Merong provision yung sexual harassment law na ang period of prescription 3 years. Pero wala namang nakalagay doon kung kailan siya magko-comment at saka kailan siya may interrupt. So you will still apply Act 3326 on commencement and interruption as interpreted by Supreme Court decision, such as panigiton, pangilinan, no? So yung Lee, na? So okay na tayo diyan. So sa Lee case, kasi public officer sa ombudsman penal, so interrupted yung running of the period of prescription. Okay tayo diyan. So balik tayo sa Jadwell. No? Jadwell 169 588 October 7, 2013. Ang ponente si Justice Leonem. Ang pinag-uusapan dito 2 months period of prescription sa violation of ordinance. No? Kasi Penal yung complaint for preliminary investigation sa fiscal within 2 months. Pero yung information, penal after nung 2 months. So kung i-consider mo yung filing of a complaint for preliminary investigation involving violation of ordinance, no? With the fiscal. Kung interrupted na, hindi prescribed. Pero kung i-consider mo yung filing ng information sa korte as a factor that will interrupt the running of the period of prescription, prescribed na. Na? Ngayon, ang sinabi ng Justice Leonem, no? Kasi pag ordinance, Act 3326 din Alam mo, the Supreme Court through Justice Leonem affirm the Saldivia principle. In-affirm niya. Sabi ng Supreme Court is that, no, ang words na ginamit nun, judicial proceedings and therefore, no, filing of a complaint for preliminary investigation with the fiscal, that is not a judicial proceedings and therefore it will not interrupt. And second, the the rules on criminal procedure, section 1 or rule 110, no? 'Di ba? Pag nag-file ka ng complaint sa fiscal, that is criminal institution of criminal action, so it will interrupt. It's not applicable because this is covered by the rules and summary procedure. No? Ngayon, ako I respect Justice Leonem, I respect the Supreme Court. Pero ibibigay ko lang yung view ko. No? Pero siyempre, Supreme Court decision yan. Pero at least kasi okay din na binibigay natin yung view natin kasi baka later on in the future, alam ko naman rito, minsan yung may mga estudyante tayo na nagtatrabaho sa Supreme Court, baka ma-re-examine itong, so, baka lang, pero in future, maulit na naman yan kung pwede naman i-affirm ulit. Pero ito lang yung view ko. No? Ito lang yung view ko. Number 1. Parang alanganin siya eh. Bakit? Kasi whether it is special law or ordinance, ang pinag-uusapan Act 3326. Act 3326. So, pag special law, abandon yung saldibiya. Interpreting Act 3326, no? So, the Act 3326, ito may saldibiya, di ba? Act 3326, ito yung saldibiya. No? Pag special law, abandon yung saldibiya. Pag ordinance, affirm yung saldibiya because of, no? Because of deed well. Ulitin ko So, Act 3326, ito may saldibiya. Pag special law, affirm, abandon yung saldibiya. Panagiton, Pangilinan, Li, etc. Pero pag ordinance, affirm yung saldibiya. Parang alanganin. Second, pag binasa mo yung rules and summary procedure, ang nakalagay yung commencements ng criminal action, pag upon filing of a yung information or complaint sa korte. Pero hindi naman nakalagay doon na the commencement of the criminal action is the one that will interrupt the running. Hindi naman nakalagay doon. At saka ito Ito, isa pa. Prior to the revision of the rules on criminal procedure, and that is December 1, year 2000. No? Ito nakalagay sa rules on criminal procedure. Ito nakalagay. The institution, pag nag-file ka ng complaint for preliminary investigation, consider siya as institution of criminal action. Tapos nakalagay sa old rules ng criminal procedure. Nakalagay doon, the institution of criminal action will interrupt the running of the period of prescription except in cases covered by the rules on summary procedure. That is the old rule. No? Ngayon, dumating tong revision, ni-revise siya. No? Ni-revise. Ang nakalagay doon, the institution of criminal action will interrupt the running of the period of prescription except those cases involving violation of special law. So, yung old rule, ang exception, ang general rule, pag nag-file ka ng complaint sa fiscal, interrupted. Ang exception, summary procedure. Yung new rule, ang general rule, pag nag-file ka ng complaint sa fiscal, interrupted. Ang exception, special law. Now, bakit nila pinalitan yung words, yung sa old rule, ang exception, summary procedure, sa new rule, ang exception, special law? Bakit? Si Herrera nag-explain. Sabi ni Justice Oscar Herrera, who is one of the members of the committee who drafted the revision of the criminal procedure. Kasi ang explanation nila doon is that hindi na gagawing yung cases covered by the rules on summary procedure as an exception to Section 1, Rule 110 of the Rules on Criminal Procedure. So in other words, the intention is that whether the case is covered by regular procedure or summary procedure, no? You apply Section 1, Rule 110. Ang exception lang special law, not no? Hindi yung cases covered by the rules on summary procedure. Na? Pero at the end of the day, that is a Supreme Court decision. No? Pero in my submission, applicable lang ang J-12 principle sa violation ng ordinance. Hindi siya pwedeng mag-apply sa felony at saka violation ng special law. Dito muna tayo sa special law. No? Sa special law. Yung People versus Pangilinan, which was reaffirmed in the case of People versus Lee, latest Supreme Court decision po yan. Anong pinag-uusapan sa People versus Pangilinan? Na nire-affirm ng People versus Lee, latest Supreme Court decision, violation of PP 22. Covered ng summary procedure yan. So ang tanong, halimbawa, violation of PP 22. Penal yung complaint for preliminary investigation within the period of prescription of 4 years. Pero penal yung information after 4 years kasi tumagal yung preliminary investigation. Now, anong susundin mo? Yung J-12 o yung Pangilinan Lee, no? O yung Pangilinan which was reaffirmed in the case of Lee. Kasi pag sinunod mo yung J-12, prescribed na yan, dismissed. Pag sinunod mo yung Pangilinan, hindi pa sa prescribed. Pwede mo kasi sundin yung J-12 kasi covered ng rules and summary procedure yan eh. Will you apply J-12? You will not. Why? Kasi J-12 is not, the Supreme Court is not sitting en banc. And therefore, J-12 cannot abandon Pangilinan. At saka yung sinabi ng Supreme Court sa J-12, hindi applicable yung Pangilinan kasi hindi naman violation ng ordinance. Now, in the case of Lee, yung Lee case na 2019, latest yan, sinabi ng Supreme Court, the Supreme Court expressly stated that J-12 did not abandon the Pangilinan principle. The factual situation in J-12 is different from Pangilinan because yung J-12 ordinance, Pangilinan, special law. So, with this pronouncement of the Supreme Court in the case of Lee, no? So parang sinasabi na, ito na, although hindi direktang sinabi, pero ito yung epekto ng principle ng Lee. Na ang J-12, ordinance yan. Pag special law, huwag natin apply yung J-12. So parang sinasabi ng Supreme Court, ordinance lang yan. Now, kung halimbawa ganito, ang pinag-uusapan oral defamation or slight physical injury, covered ng rules on summary procedure to. Penal yung complaint for preliminary investigation within 2 months. Pero penal yung information sa korte after 2 months. Nag-file ng motion to quash. Ngayon, pag sinunod mo yung J-12, summary procedure to eh. Following na J-12, filing of complaint for preliminary investigation will not interrupt. Now, controlling ba yung J-12? J-12 cannot abandon the Francisco. Binanggit ko na yung GR number ng Francisco. Yung Francisco Doctrine, nire-affirm na yan ng rule, ng Section 1, Rule 110 of the Rules on Criminal Procedure. Jadwell cannot abandon the Francisco. Hindi naman NBAC yun, Jadwell. Yung di ba? Hindi niya kayang i-abandon yan. Ang Francisco slight physical injury covered by the rules and summary procedure. And then the simple oral defamation. Yung Bautista slight physical injury, they affirm the Francisco even if the case is covered by the rules and summary procedure. So the filing of a complaint for slight physical injury for preliminary investigation with the fiscal will interrupt. Saka second, bakit hindi mag-a-apply ang Jadwell? The Jadwell is interpreting Act 3326. No? While Francisco is interpreting Article 91 of the Revised Penal Code kasi simple oral defamation eh. So how can you apply a principle by the Supreme Court interpreting Act 3326 to a case which is not governed by Act 3326? And that is simple oral defamation. This is subject to Article 91 of the Revised Penal Code. No? So under Article 91, no? Basahin mo yung Article 91. Oh, nakalagay ba doon na ang slight physical injury is not covered by Article 91? Nakalagay ba doon yung oral defamation is not covered by Article 91? Can the rules on summary procedure issued by the Supreme Court amend Article 91 of the Revised Penal Code? Depende. Prescription substantive yan eh. Na? Pero ito for purposes of, isa-summary ko na lang para for purposes of the bar examination, ganito yung strategy. No? Pag violation of BP 22, 4 years ang period of prescription yan. Covered ng summary procedure. Huwag niyong banggitin yung na-covered siya ng rules on summary procedure. Basta ang pinag-uusapan dito, prescribed na ba? Nagkaroon ba ng interruption? So, ganito lang explanation para simple lang. Ganito lang explanation. So, under Act 3326, the 4 years period of prescription, the running of the 4 years period of prescription will be interrupted by the institution of judicial proceedings for investigation or punishment. Judicial proceedings should be interpreted as administrative and judicial. There is an administrative judicial proceedings for investigation once a complaint for preliminary investigation was filed in the fiscal. And there is institution of judicial proceedings for punishment if a complaint or information is filed in court for trial on the merits. Thus, the filing of a complaint for violation of PPT 22 for preliminary investigation with the fiscal will interrupt the running of the period of prescription. So, okay tayo dyan. Now, pag halimbawa, ang pinag-uusapan slight physical injury or simple oral defamation, huwag niyong banggitin na covered sa ng rules and summary procedure. Ang issue lang naman dito, prescribed na ba? O ito, explanation dyan. Under Article 90 of the Revised Penal Code, 91 pala. No? The running of the period of prescription will be interrupted by filing of information or complaint. Now, the complaint, no? The meaning of complaint is the concept of the complaint includes a complaint filed for preliminary investigation with the fiscal and a complaint filed in court for trial on the merits. Now, the law did not distinguish whether the complaint pertains to that filed in court for trial on the merits. If the law does not distinguish, the court must not distinguish. And therefore, the filing of a complaint for preliminary investigation involving slight physical injury with the fiscal will interrupt the running of the period of prescription. Now, third situation. Ano ang tanong sa bar? Ordinance. Ordinance. Ganito, explanation nyo, mag-iiba na. So, under Act 3326, to interrupt the running of the period of prescription, there must be institution of judicial proceedings for preliminary investigation or punishment. Preliminary investigation is not a judicial proceeding, and therefore, the filing of a complaint for preliminary investigation with the fiscal will not interrupt the running of a period of prescription. And second, under the rules of criminal procedure, the filing of a complaint for preliminary investigation will interrupt the running of the period of prescription. But this is not applicable because violation of ordinance is covered by the rules on summary procedure. So, okay na tayo sa updates. Kung merong questions, pwede naman. Rex, okay na tayo. Meron pa tayong 15 minutes. 20. Kung gusto nyo ng open forum, pwede naman.
Kaya ako paliwanag.
Unless na ayaw na nila. Meron, wala.
Hey,
Wala.
Judge. Let me check po sa Facebook page.
Sige, ano sabi?
Judge.
Titignan ko sa Facebook.
Yes, Judge.
Paano ko makikita? Sige na nga.
Actually, Judge, puro thank you and...
Oo.
Yes.
Nasa na?
Questions.
Ano ba yung question? Ako, hanapin ko ha. Saan ba yung... Sadali lang ha. Nalito na ako ha. Di pwede basahin mo na lang? Hindi, siya, bas mo. Sadali lang ha. Page filter.
If you have questions po, kindly comment na lang po on our Facebook page.
Hindi ko makita yung Facebook page.
Hey, Judge, binabasa ko naman po. Or on thank you po eh.
Ito pala. Ito. Inbox. Sige, basahin mo na lang. Ito, sandali lang ha. Para mabasa ko. Ayun. Bakit ayaw? Basahin mo na lang nga.
Judge, meron pong isa.
Sige, ano yun? Isa lang. Sige, mas maganda kung isa lang. Ito. Yan. Yan. Ito na. Tapos, nasa yung inbox. Basahin mo na nga. Ito pala.
Jury sa BP22 na after 5 banking days, start running of press.
Ano na?
Ito, prescriptive period po and venue to file RA 4200.
RA
00 po. 4200.
Ano yung anti-wire?
00, Judge.
4200?
Prescriptive period po and venue to file. Yes po.
Nasaan? Kaya nga, tanong mo yung anti-wire tapping? Ang tanong ba, anti-wiretapping? Act 4200?
Yes po. Yun lang, Judge.
Hindi, yung
Prescriptive period po and venue to fact.
yung wala sa Act 4200, walang provision on period of prescription. So you will go to Act 3326. Ngayon ang penalty niyan, ang alala ko hanggang hanggang 6 years. No? Sa Act 3326, pag 6 years or more, 12 years yung period of prescription. Ang problema yung ang pinaka penalty niya, yung pinaka maximum penalty 6 years eh. Oh. Ang nakalagay doon 6 years or more. So papasok siya doon sa phraseology ng 6 years or more. No? So 12 years. Now, ganoon din. Pag nag-file ka ng, you follow the case of Pangilinan, Lee, Panigiton, no? Pag nag-file ka ng complaint for preliminary investigation, interrupted na yan. You will not apply the J-Dwell principle. Kasi yung in the case of Lee, sinabi ng Supreme Court, no, ang J-Dwell applicable, no? Ang pinag-uusapan doon ordinance. So pag hindi ordinance, you will not apply J-Dwell. Yun ang sinabi, latest Supreme Court decision at Lee, 2019 yan. O ano pang tanong? Okay na tayo doon. O wala nang tanong. Pwede tayo magpahinga.
Judge.
Ano mo na? Ano mo na? Winding up ka na. Bibili kayo ng book ko, ha? Saka ako, yung mga magbabar, meron akong 7 days lecture. Makikita niyo yung talent ko doon. Ha? Makikita niyo yung tunay na talent ko pag pinatanan niyo yung 7. Kung may talent ako, ha? O, yun. Okay na? O, sige na. Pack up na.
Yes po.
Magsasalita ka. Hindi na.
On that note, we have come to the end of to everyone who joined us this evening, thank you for learning with us and for choosing Rex to be your partner in learning. See you all on our next bar lecture. Thank you po, and good evening. Thank you po, Judge.
Meron tayong, susunod na, pre-lecture natin? March, announce mo sa kanila? March, Parang
wala pa po tayong final.
Wala pa. O,
March 5, Judge.
Yung page account ko, ha? Kasi yung pala
sa Facebook.
Ang okay lang, 32,000. No? Pakidagdagan nyo na lang, ha? Please. Minsan na may mga updates ako pinopost ko doon. Ha? Bye-bye.
Thank you po. Thank you, Judge.
Salamat.